my name is Agata, and I will now respond to the arguments raised by the opposing party in the suggested order. Therefore, the respondent submission will also be divided into two main points. That firstly, the claimant is not entitled to seek contract adaptation under the hardship clause, as the imposed tariff did not constitute hardship under clause number 12, and also the contract does not provide for a remedy such as contract adaptation.
Yes.
And secondly, that the claimant should be stopped from seeking contract adaptation under the contract law, that is the CISG, a gap filled by the provisions of the UNIDROIT principles. Members of the tribunal, in these proceedings, we are facing the issue of contract adaptation, which under present circumstances require two key elements. First, the consent of the parties to such a remedy, and secondly, the event that causes hardship, neither of which are present in the foregoing case. Therefore, with regard to the first submission, it is the respondent's position that the imposed tariffs did not constitute hardship under the hardship clause. And in order to prove that, I kindly ask to follow page number 14, that is the hardship clause already known to this tribunal.
Yes.
Under clause number 12, it states, seller shall not be responsible for, and the second last line, hardship caused by additional health and safety requirements or comparable unforeseen events making the contract more onerous. In order for hardship to be present, all three requirements would need to be fulfilled. That is, the tariffs would need to be comparable to health and safety regulations, unforeseen, and to make the performance of the contract more onerous. And as a preliminary remark, I would like to remind this tribunal that all three requirements would need to be fulfilled, and none of them are.
Why do you say all three? Additional health and safety requirements or comparable unforeseen events?
It was the parties. It is the that was the party's intention that all three requirements would need to be fulfilled. As
where do you get that from?
The comparable unforeseen events need to make the performance of the contract more onerous.
No doubt about that.
And the imposed tariffs are not health and safety regulations. The opposing party may try to attempt seeking that they were comparable unforeseen events.
Yes, well that would be it, wouldn't it? You say they're not comparable.
They are not comparable, not unforeseen.
Additional health and safety requirements are not comparable to additional tariffs.
That is correct. And also, the other remaining two arguments, unforeseeability and making the performance of the contract onerous, were not fulfilled either. Starting with the first requirement, that is the comparable, the opposing counsel has cited a sentence from page 12 of the record. They kindly ask to follow that page. In that page, the claimant has indeed stated that he is not willing to take over further risks associated with delivery terms. However, we must take a step back, and in order to assess what the parties meant by
page 12, you say? Sorry.
That is correct.
Yeah.
Fourth paragraph. In order to assess what the parties meant by the category as comparable unforeseen events, we must take into consideration the intent of the parties in line with Article 8 of the CISG, and that is the subjective intention of the parties. We must take a step back and not only look at how, but also why the parties included the hardship clause into their contract. In that very email, the claimant has been describing its past unpleasant experience with the imposition of additional health and safety regulations, and to these kind of events, it's stated at the bottom of fourth paragraph, at minimum a hardship clause should be included into the contract to address such subsequent changes, meaning changes compared to health and safety requirements, and imposed tariffs as retaliatory mechanism are not comparable. They serve different.
Can I ask though, the wording in the email says changes in customs regulation or import restrictions. Would you consider health and safety restrictions to fall under one or both of these categories?
It is our client's submission that the customs regulations or import restrictions were only in terms of health and safety regulations. We need to take into consideration the second sentence and why the claimant insisted on inclusion of the hardship clause. And also, it is confirmed by the fact that the respondent rejected initially proposed ICC hardship clause by the claimant, as it considered the standard hardship clause too broad. The parties enumerate.
I'm so sorry to interrupt. But when in the paragraph you're just talking about, they then go on to explain why it is that they would find health and safety requirements bad? And the answer is because of money, because it will increase the cost by up to 40% and thereby destroy the commercial basis of the deal. Doesn't that suggest that the concern is not so narrow?
It was in that email, that is correct. The claimant has been has provided the respondent with the price increase of 40%. However, in terms of the categories that constitute hardship, the 40% requirement cannot impact general categories, can only impact the demanded threshold of hardship, and that would be the first requirement that is making the performance of the contract more onerous, that can impact the understanding between the parties. When it comes now to the making the performance of the contract more onerous, it was not elaborated further by the opposing counsel. However, the tariffs, indeed, they amounted to 30% of the price increase. However, they only concerned half of the goods ordered. Therefore, when you take into consideration the whole contract, the price increased merely by 15%, which is nowhere near the demanded threshold of hardship in the doctrine. For example, Professor Brunier stated that the alteration of the price at least amounting to 50% can constitute hardship. 15% is nowhere near the demanded threshold. And also, as to the requirement for the unforeseeability, it is the respondent's position that the tariffs were hypothetically being able to be foreseen, as they were a political chain of events. The president of Mediterranean was elected prior to the contract conclusion, and he announced in his program that he would be undertaking a more protectionist approach. However, what is even more important is that the tariffs were introduced in December, and the claimant only inquired with the ministry before the last shipment whether the imposed tariffs on agricultural products would also cover such a specific good as frozen rice for seamen. If the claimant hypothetically asked in December, the parties could have moved the date of last shipment and avoid the imposition of tariffs. Also, when it comes to the remedy available under clause number 12, it is our client's submission that the clause does not provide for a contract adaptation. As pointed out by Mr. Presiding Arbitrator, the clause provides seller shall not be responsible for. The parties added hardship clause into the already existing force majeure clause. They created a hybrid with one remedy available in cases of both force majeure and hardship, and that is the exemption from liability and not contract adaptation. Also, the claimant should be stopped from relying on its poor financial situation. In the negotiations between the parties, the claimant never voiced its concerns and never actually informed the respondent that it was bearing some financial difficulties. If it did not think that this information was vital prior to contract conclusion, it should be stopped from relying on these grounds at the present stage of the proceedings. And as to my second submission, it is also the respondent's position that the claimant cannot seek contract adaptation under the contract law, as first of all, Article 79 does not govern situations of hardship, but only impossibility. However, even if this tribunal finds that Article 79 can be extended to the economical erroneousness, still the parties derogated from Article 79 as they included the hardship, specific tailor-made hardship clause into their contract. Starting with my first point, Article 79 of the CISG refers to the notion of impediment beyond the parties' control. It was found in the case law, for example, in the iron chrome case or sunflower seeds case, where in both cases the CISG was the contract law, that the CISG does not extend to the changes in economical background, it only deals with force majeure as such. Also, it was reflected in the drafting history of the CISG as the drafters discussed the possibility of inclusion of hardship provisions into the CISG. However, at the end of the day, they decided to leave it out of the convention. However, alternatively, if this tribunal finds that we can extend Article 79 to situations of economic erroneousness, it is the respondent's position that the parties derogated from Article 79, not due to one, but due to two reasons. First of all, the parties included the hardship clause into their contract, which is the most common way to derogate from Article 79 of the CISG. Force majeure and hardship clauses were found, for example, in the automatic diffractometer case, which was also based on the CISG, that they impliedly derogate from general provisions of the CISG, and in that particular case, that is the automatic diffractometer case, the court has prevented the party from relying on Article 79 of the CISG, as the parties enumerated the events constituting force majeure in that case. Moreover, the second reason is that the parties have decided on a DTP type of delivery, as was pointed out by my opposing counsel. And DTP type of delivery is the Incoterm that burdens the seller, that is the claimant, with majority of the risk regarding transportation, that is customs, taxes, all types of fees and payments. In that case, the parties can derogate certain provisions of certain Incoterms, and that is what the parties did. On page 14, we can see what kind of obligations the parties excluded from a DTP type of delivery. Under clause 10, it is stated buyer is responsible for all tank rental and handling fees. And if, for example, in clause number 13, it is stated the frozen semen is not insured during shipment. Therefore, the parties amended DTP type of delivery only with relation to the express exclusions. There is nowhere stated in the contract that customs would be excluded from the sphere of obligations of the seller. Also, the financial aspect of the contract proves that the claimant assumed the risk. The claimant demanded $500 of a price increase due to the cost of shipment. However, direct cost of shipment only concerned $200. Therefore, the claimant asked for $300 more per one dose. In terms of the whole contract, $30,000 more for the assumption of risk.
Sorry.
And
why do you consider clause 12 not to be an implicit carve out from the DTP in relation to risks of customs increase? I mean, when you look at the wording that you had cited earlier on page 12, it quite clearly says that the parties weren't willing to take any, at least that the claimant wasn't willing to take on any further risks associated with such change in delivery terms, and specifically in customs regulation or import restrictions. So why do you think that's not a cover from DTP?
Mr. Arbitrator, to answer that question, it is the respondent's position that in general, hardship clause is the exemption of DTP in terms of health and safety regulations or comparable unforeseen events. However, as I stated before, the imposed tariffs as a retaliatory mechanism are not comparable to health and safety regulations. They serve different purposes. The first category is to prevent transmission of diseases. In the second one, it was the political retaliation. And as to the argument that the opposing counsel has stated that our client has acted against the principle of good faith, it must be emphasized that Mr. Greg Shoemaker, that is the respondent's employee, did not make any promises to the claimant. It merely stated that he was not empowered, he was not authorized to adopt the contract. However, if the contract provides for contract adaptation, the parties will find an agreement. The contract does not provide for a remedy such as contract adaptation. Therefore, the claimant should be stopped from seeking the remedies the parties did not agree upon. And as to the conclusion of both of my submissions,
Yes.
it is the respondent's position that the claimant is trying to overstep the contractual lines, taking the advantage of its poor financial situation. However, the claimant should be stopped from seeking the remedies it has no right to. And therefore, it is the respondent's position that the claimant should be stopped from seeking contract adaptation under the hardship clause and also under the contract law.
Thank you very much. Rebuttal.
Yeah. Thank you, Mr. Presiding Arbitrator. Respondent itself suggested the wording of the clause 12, therefore the hardship clause, referring to Ms. Nabravnik's email stating expressly also import restrictions like the retaliatory tariffs at the case at hand. The word comparable is referring to events making the contract similar, more onerous, like health and safety requirements. The health and safety requirements were only an example for an event which already happened in the past on the claimant's side. So therefore the tribunal should be able to adapt the contract under clause 12 of the sales agreement. Thank you, members of this tribunal.
And members of the tribunal, it is correct that it was the respondent who decided on the final version of the hardship clause. However, the respondent drafted the hardship clause based on the experience of the claimant had with health and safety regulations. And as I stated, the respondent rejected ICC hardship clause as the parties wanted only enumerated types of events to constitute hardship. Thank you.
Thank you very much. Well, now, if you can leave us all well.